Are you considering quitting employment due to intolerable working conditions? Have you ever been in employment circumstances where your employer makes your working conditions so intolerable that you feel compelled to leave your employment? Although there is no actual dismissal, your treatment is sufficiently bad that you regard yourself as having been unfairly dismissed. In many jurisdictions, the law recognizes instances where an employee is rendered unemployed by virtue of the misconduct of an employer and refers to it as constructive dismissal from employment. Instances in which constructive dismissal may arise include where an employer, without prior consultation with the employee, unilaterally changes fundamental terms of an employment contract such as salary, working hours, job description, or even refuses to allocate work to the employee. Where an employee considers making a claim for constructive dismissal, the following matters should be borne in mind. 1. The employee must resign as a result of the fundamental breach. Resignation by the employee should be directly related to the conduct of the employer that gave rise to the fundamental breach. It has previously been held that an employee who resigned because of constantly being transferred from one region to another without being given time to settle was constructively dismissed and therefore entitled to compensation. On the other hand, the courts have held that resigning out of a fear of being dismissed does not amount to constructive dismissal. 2. The employee must not delay in resigning after the breach has taken place. Otherwise, the court may find the breach waived. A delay in resigning only means that the employee by conduct was agreeable to his employer's misconduct. The employee must therefore resign within a reasonable time, so as not to be seen to be condoning the employer's misconduct. 3. Where the employee resigns in writing. The letter should clearly state the reasons for the resignation and make reference to any previous correspondence detailing the misconduct of the employer that constitutes the fundamental breach of the employee's contractual terms of employment. In the letter, the employee should not include comments that may allude to having enjoyed working for the employer, as those may be considered inconsistent with a claim that an employee resigned on account of an intolerable working environment. The employee should clearly outline in the letter the effect that the employer's conduct has had on the employee's working life so as to create the feeling that there was no choice but to resign. Employees who believe they are facing constructive dismissal should consider seeking legal advice and exhausting internal grievance procedures if available. Employers should be aware of the potential legal consequences of making significant changes to an employee's conditions of employment and should strive to maintain fair and transparent workplace practices.